My name is Nadia Callum, and I was 32 years old when a woman from a title company called me on a Wednesday afternoon while I was grading papers at my kitchen table and told me that the refinancing on my parents' house had hit a problem. I said, "I am sorry, what refinancing?" She said, "The application your brother submitted last month." I said, "What application?" She said, "The one listing you as co-owner on the deed." I said, "I am not on the deed." She went quiet for a moment, not the quiet of someone who has nothing to say, the quiet of someone who has just understood that the conversation they are having is a different conversation than the one they thought they were having. She said, "Miss Callum, I think you need to come in." I set my red pen down on the stack of fourth-grade reading comprehension tests, and I looked at the wall in front of me, and I thought about my brother Marcus, who was 36 years old and had lived in my parents' house for the last 9 years, who called me every birthday and every Christmas and every time he needed something. And I thought about the last time I had spoken to him, which was 3 weeks ago, when he called to ask if I remembered where Dad kept the insurance paperwork. I had told him I did not know. I had thought nothing of it. I said to the woman on the phone, "What exactly is on the deed?" She told me, and I sat at my kitchen table with fourth-grade reading tests in front of me and understood that my brother had been lying to me for 6 years. Before I tell you what was on that deed, let me tell you about my family, because context is the thing that makes a story make sense, and without it you are just watching something happen without understanding why it was able to happen at all. My parents, Robert and Elaine Callum, bought their house in 1987, 3 bedrooms, a small yard, a street in a neighborhood that was ordinary in every way that a neighborhood can be ordinary, and was home in every way that a place can be home. My father worked in logistics, my mother was a school secretary, which is how I ended up a teacher, following the particular gravity that parents exert on children without meaning to. They paid that house off over 23 years. I want you to understand that. 23 years of mortgage payments on 2 ordinary salaries, raising 2 children, putting money away, not taking vacations they could not afford, buying the store brand when the name brand cost more. That house was the physical evidence of everything they had built together. It was not valuable in the way that things in cities are valuable. It was valuable in the way that things built slowly and honestly are valuable, which is a different kind of value, and in some ways a more important one. My father died in 2016, heart failure. He was 67 and had seemed healthy, and then was not, and then was gone, in the particular sudden way that makes you understand for the first time that the world does not ask your permission before it changes on you. My mother followed him in 2019, cancer, diagnosed late, moved fast. I held her hand in the hospital and she told me to take care of Marcus, and I said I would, and I meant it, and I have thought about that promise every single day since the title company called. Marcus is 4 years older than me, and has always been the kind of person who is very good at appearing to have things handled. This is a specific skill, and I want to name it clearly, because it is different from actually having things handled, and the difference matters enormously when you are the sibling who moved away and trusted the one who stayed. He is charming in the way that people are charming when they have learned that charm is more efficient than effort. He makes people feel at ease immediately. He remembers details about people's lives and asks about them in ways that feel genuine, even when they are strategic. He is funny. He is warm when he wants to be. He is the kind of person that people describe as a good guy and mean it sincerely, and are not wrong exactly, just incomplete. When my mother got sick, it was Marcus who stayed. I was living 4 hours away by then, teaching at an elementary school, in the middle of a life I had built carefully and incrementally, the way our parents had built theirs. I drove back every other weekend. I called every day. I handled what I could handle from a distance. Marcus handled what required presence. He took her to appointments. He managed her medications. He dealt with the hospital paperwork and the insurance calls and the particular grinding administrative weight of watching a parent decline. I was grateful. I told him so regularly. I sent money when he said things were tight. I trusted him completely because he was my brother and my mother had asked me to take care of him, and because I did not yet understand that trust extended without verification is not love, it is exposure. My mother died on a Tuesday in November 2019. I drove up that weekend, and Marcus and I sat in the house that still smelled like her and went through the practical things that need to be gone through when a parent dies, the paperwork and the accounts, and the decisions about what to keep and what to let go. The will was straightforward. My parents had written it together years before my father died and updated it after he passed. The house was to be split equally between Marcus and me, 50% each. Marcus could continue living there if he chose to, which the will specified explicitly, but the ownership was equal, and any decision to sell required both signatures. I remember Marcus reading that section and nodding and saying, "That is fair, that is exactly right." I remember thinking he seemed genuinely at peace with it. I remember feeling relieved that there was not going to be a fight about it, because I had heard enough stories from colleagues and friends about inheritance disputes turning families into something unrecognizable. I did not want that. I wanted my brother. I wanted the house to be a thing that connected us to our parents and to each other, and not a thing that divided us. I signed the documents the estate lawyer put in front of me. I drove home on Sunday evening. I called Marcus on Monday to check in. He said he was okay. He said he would start going through Mom's things slowly. There was no rush. I said, "Take your time." I said, "Let me know if you need anything." He said, "You are a good sister, Nadia." I said, "You are a good brother." We both meant it. Or I did. I cannot speak for him anymore. The years between my mother's death and the title company's phone call were quiet in the way that years are quiet when nothing appears to be happening. Marcus lived in the house. I visited twice a year, at Thanksgiving and in the summer. The house looked maintained. Marcus seemed stable. He worked intermittently, contract work in facilities management, enough to cover his living expenses, he said, and I did not ask too many questions, because asking too many questions felt like distrust, and distrust felt like a failure of the promise I had made my mother. I paid half the property taxes. This is important. Every year, Marcus would send me the tax bill, and I would send him my half by bank transfer. I thought this was normal. I thought this was what co-ownership looked like in practice. I did not think to look at the deed itself, because why would I? My name was on it. The lawyer had filed everything. The estate had been settled properly. I had been there. I had signed the documents. Except, as I would learn on that Wednesday afternoon with fourth-grade reading tests in front of me, there were two sets of documents, the ones I had signed in the lawyer's office in November 2019, and the ones that had been filed with the county recorder's office in March 2020, 4 months later, which listed the ownership percentages as 80% Marcus Callum and 20% Nadia Callum, and which bore my signature on the ownership amendment form, a signature I never wrote, on a document I never seen, changing terms I never agreed to. I drove to the title company the next morning. I called in a substitute for my class, which I had done exactly 4 times in 7 years of teaching, and each time felt like a small personal failure, and I drove 40 minutes to an office building in a business park and sat across from a woman named Karen Asai, who had the careful, measured manner of someone who has learned to deliver difficult information without editorializing. She showed me the deed. She showed me the amendment. She showed me my signature, or rather the thing that was supposed to be my signature, on the amendment document. I looked at it for a long time. It was close. It was genuinely close. Marcus had always seen me sign things. He had my signature on birthday cards, and the occasional check I had written him over the years, and the estate documents from 2019. He had material to work from. But it was not right.
The way I make my capital N is specific, a habit I made in college and have never changed, and the signature on that document made the N differently, confidently but differently, the way someone makes a letter when they have practiced it but don't actually own it. I said, "This is not my signature." Karen Asai said, "I was concerned it might not be." I said, "How did this happen?" She said, "The amendment was filed directly with the county recorder. Title companies are not involved in that process. We only discovered the discrepancy because your brother's refinancing application required a full title search, and the ownership percentages triggered a flag that required us to contact all parties on the deed." I said, "So he applied for a refinance?" She said, "Yes." I said, "On a property he does not fully own?" She said, "On a property where the ownership record does not match the original probate documents." I said, "What happens now?" She said, "That is entirely up to you."
I sat in my car in the parking lot of that business park for 45 minutes before I drove anywhere. I am a person who processes things slowly, and I have made peace with that about myself. I am not someone who reacts in the moment with clarity. I am someone who needs to sit with a thing, turn it over, look at it from several angles, and then decide what it means and what to do about it. What I was sitting with was this. My brother had forged my signature on a legal document. He had done it 4 months after our mother died, while I was grieving, while I trusted him completely, while I was 4 hours away living my life and believing that the people I loved were who I thought they were. He had changed the ownership split from 50-50 to 80-20 in his favor. He had been collecting the full benefit of that 80% for 6 years, while sending me property tax bills for 50% of a house I apparently owned only 20% of. He had called me on my birthday every year. He had called me at Christmas. He had said, "You are a good sister, Nadia," and I had said, "You are a good brother, Marcus." And the whole time he had been living in a house that he had quietly, deliberately, and illegally rewritten in his favor, while I paid taxes on a share I was not actually receiving. I did not cry in that parking lot. I'm not sure why. I think I was too far past the feeling that produces tears and into the feeling that produces decisions. I called my friend Della from the parking lot, not because Della is a lawyer, she is not, she teaches 5th grade 2 classrooms down from mine, but because Della is the person I call when I need to say something out loud before I know what I think about it. She answered on the second ring. I told her what had happened in the flattest possible voice, the voice I use when I am holding something together that would rather come apart. She was quiet for a moment, and then she said, "Nadia, that is a crime." I said, "I know." She said, "You need a lawyer." I said, "I know that too." She said, "Are you okay?" And that was the question that nearly undid me, because I had been holding everything else but that question, the simple one, the one that assumes you might not be. That was the one that found the gap in my composure. I said, "I do not know yet." She said, "Okay." She said, "Do you want me to come with you somewhere?" I said, "No." I said, "I need to think." She said, "Call me when you are done thinking." I said, "I will." I sat for another 10 minutes, and then I drove home and I sat at my kitchen table, the same table where I had been grading papers the day before when everything was still the shape it had been for 6 years, and I opened my laptop and I started looking for a real estate attorney. Not because I had decided what to do yet, because I needed to understand what my options were before I could decide anything. Information first, decisions after. That is how I have always worked, and it has served me consistently. I found an attorney named Patricia Voss, which I noted with the particular irony that sometimes the universe delivers without meaning to, a woman who specialized in real estate litigation and estate disputes, and whose initial consultation fee was $250, which felt like a lot on a teacher's salary and felt like nothing compared to what was at stake. I booked the earliest available appointment, which was 4 days away.
In those 4 days, I did not call Marcus. I want to be specific about this, because it was a deliberate choice, and not an easy one. My instinct, the instinct of a person who has always believed that direct conversation is better than silence, was to call him immediately and ask him to explain. But I thought about what Karen Osei had said. That is entirely up to you. And I thought about what Della had said. That is a crime. And I understood that if I called Marcus before I had legal advice, one of 2 things would happen. Either he would deny everything, and I would have warned him that I knew, giving him time to prepare, or he would admit it, and I would have had an important conversation without any of the legal context I needed to have it properly. Either way, I would be at a disadvantage. So I did not call. I went to school, I taught my students about fractions and read-alouds and the water cycle. I graded their papers in the evenings. I called Della once a day and said I was fine. I was not fine, but I was functional, which is sometimes the best available option, and is not nothing.
Patricia Voss had an office that looked exactly like you would want a real estate litigation attorney's office to look. Organised, serious, with the particular density of paperwork that signals someone who deals with the weight of things. She was in her late 50s. Direct, in the way of people who have spent decades in rooms where indirectness costs money, and she listened to everything I said without interrupting. I had brought everything I had, the original probate documents from 2019, the property tax bills Marcus had sent me over the years, which I had kept in a folder, because I keep everything in folders, a habit inherited from my mother, who kept everything in labelled folders and believed that organisation was a form of self-respect. I had screenshots of the bank transfers showing my half payments of the tax bill every year. I had the deed information Karen Osei had shared with me. Patricia Voss looked through all of it with the focused attention of someone who is simultaneously absorbing information and building a framework for it. When she finished, she set everything down and looked at me and said, "What you are describing is deed fraud. It is a felony in this state. The forged signature on an official recorded document, combined with the financial benefit your brother derived from the altered ownership split, constitutes criminal fraud and potentially theft by deception, given the tax situation." I said, "What are my options?" She said, "You have several, and I want to walk you through all of them so you understand the full picture before you make any decisions." I said, "Please." She said, "Let us start from the beginning." Patricia Voss laid out my options in the clear, sequential way of someone who has explained difficult situations to people in shock enough times to have developed a method for it. Option 1. Civil litigation. I could sue Marcus directly for fraud and seek damages, including the difference between the 50% ownership I was entitled to and the 20% he had recorded, plus any financial benefit he had derived from the altered ownership split over 6 years. This would be a civil matter, handled in civil court, and would not result in criminal charges unless I separately pursued that avenue. Option 2. Report to law enforcement. Deed fraud is a criminal matter, and I could file a report with the county sheriff's office or the district attorney's office, which would trigger a criminal investigation independent of any civil action I chose to take. Option 3. Both. Civil and criminal are separate tracks, and pursuing one does not preclude the other. Option 4. Negotiate directly with Marcus, with attorneys present, to restore the correct ownership and reach a financial settlement without involving the courts. She said, "Option 4 is the fastest and least expensive, but it requires your brother to cooperate, which people in his position do not always choose to do when they understand the alternative is not clearly presented to them." I said, "What would you recommend?" She said, "I would recommend sending a formal letter through my office informing your brother that you are aware of the deed amendment, that you have retained counsel, and that you are prepared to pursue all available legal remedies unless he agrees to meet with his own attorney to discuss restoration of the correct ownership and appropriate compensation." She said, "In my experience, that letter produces 2 responses, either cooperation or panic. Either way, you learn something important about what you are dealing with."
We sent the letter. Patricia Voss drafted it in the precise legal language that I could understand, but that Marcus would need an attorney to fully pass, which was intentional. It outlined the discrepancy between the original probate documents and the recorded deed amendment. It referenced the forged signature. It stated that I had retained counsel and was prepared to pursue all available legal remedies unless he agreed to meet with his own attorney to discuss restoration of the correct ownership and appropriate compensation. I signed it. Patricia's office sent it certified mail on a Friday. I spent that weekend doing the things I do when I am waiting for something I cannot control. I cleaned my apartment with unusual thoroughness. I made a large batch of soup I did not particularly want. I called Aunt Rosemary, who was my mother's sister and the only member of the older generation still living who had known Marcus and me as children. I did not tell Aunt Rosemary what was happening. I just wanted to hear someone who loved me without complication, without agenda, without the particular weight that the situation with Marcus had placed on every interaction I was now having in my head. She told me about her garden and her neighbour's dog and a book she was reading, and I listened and felt, for an hour, like a person whose life was still the straightforward thing it had been before a title company called on a Wednesday afternoon. Then I hung up, and the weight came back, and I sat with it because sitting with things is what I do, and because I did not yet know what Marcus was going to do, and until I knew that, I could do nothing except wait.
Marcus called me on the 9th day, not through an attorney, directly. His name on my phone screen on a Tuesday evening while I was eating dinner alone at my kitchen table, the same table. Always the same table, which had become, in my mind, the place where my life kept delivering information I had not asked for. I let it ring 4 times while I decided to answer. I answered. He said, "Hey." I said, "Hey." He said, "I got a letter." His voice had the quality of someone who is performing casualness over something that is not casual at all, the verbal equivalent of walking slowly when you want to run. I said, "I know you did." He said, "Nadia, I can explain." I said, "Okay." He said, "It is not what it looks like." I said, "Marcus, I have seen the deed. I have seen the signature. I have spoken to an attorney. Tell me what it looks like to you, and then tell me what it actually is, because I am interested in the second thing and not the first." There was a silence, a long one, the kind of silence that has texture to it, that you can feel the weight of through a phone. Then he said, "I needed the equity." I said, "What?" He said, "A few years ago I was in a bad place financially, and I needed to access some of the equity in the house, and I could not do it as a 50% owner. The bank would not approve it. And I thought, Nadia does not need this right now. She has her job, she has her life. I thought I would fix it later." I said, "You forged my name on a legal document." He said, "I know." I said, "And then you sent me tax bills for 6 years. He did not say anything. I said, "Marcus, how much equity did you pull out?" Another silence. He said, $84,000. $84,000. I want to sit with that number for a moment because I think it deserves a moment. My brother had forged my signature, altered the ownership of a property that belonged equally to both of us, and used the fraudulently obtained ownership majority to pull $84,000 in equity out of our parents' house. The house our parents had paid off over 23 years on 2 ordinary salaries. The house our mother had died in. The house I had visited twice a year and sat in and felt the presence of people I loved in every room of. He had borrowed against it. He had borrowed against our parents' legacy without asking me, without telling me, while sending me annual tax bills and calling me on my birthday and saying, "You are a good sister, Marcus." I did not say any of this on the phone. I said, "I need you to understand something clearly, Marcus. I have a lawyer. What you did is called deed fraud, and it is a felony. I am not calling you tonight to yell at you or to tell you what kind of person I think you are. I am calling because you called me, and because I think you deserve to hear directly from me before this goes any further that I am not going to let this go." He said, "Nadia, please." I said, "You need to get an attorney." He said,
"I cannot afford an attorney." I said, "That is not my problem." He said, "This is going to destroy my life." I said, "You built this. You built it over 6 years, one decision at a time. I did not build it." I held the phone and felt something that was not quite anger and not quite grief, and was perhaps the specific feeling you have when you understand that someone you loved was not entirely the person you loved. I called Patricia Voss the next morning and told her about the conversation. She listened, and then she said 2 things. First, she said I should not speak to Marcus again directly, that all communication should go through counsel now that he was aware of the situation and had effectively admitted to the forgery in a phone call. Second, she said the admission on the phone was significant. I said, "I did not record it." She said, "That is fine. Your account of the conversation is still relevant, and his admission tells us something important about how he is likely to approach this, which is that he is scared and not yet thinking strategically. Scared people sometimes cooperate quickly and sometimes dig in and deny everything once they've had time to compose themselves and consult someone. We need to move before he has too much time to do the second thing." She recommended we take 2 parallel steps immediately. File a complaint with the County District Attorney's Office documenting the deed fraud, which would initiate a criminal investigation independent of our civil action, and file a lis pendens on the property, which is a legal notice that essentially freezes any transactions on the house, including the refinancing Marcus had applied for, until the ownership dispute is resolved. I said, "Do both." She said, "I was hoping you would say that." I want to be honest about something. Up to that point, I had been operating in a kind of suspended state, processing and deciding without fully feeling. When I said, "do both," I felt something shift. It was the feeling of a decision becoming irreversible, of choosing a direction and beginning to move in it. It was not a good feeling exactly, but it was a clear one. The lis pendens was filed within the week. Marcus's refinancing application was effectively dead the moment it was recorded. I learned this not from Marcus directly, because we were no longer speaking directly, but from Patricia Voss, who received a call from a man named Gary Thibodeau, who identified himself as a friend of Marcus's with some legal background, not an attorney, who wanted to understand what was happening and whether there was a way to resolve things quietly. Patricia told him that if Marcus wished to resolve things, he needed to retain an actual licensed attorney, and that her resolution she was authorized to discuss on my behalf would require full restoration of the 50% ownership, repayment of the equity Marcus had withdrawn, plus 6 years of interest, and a formal acknowledgement of what had occurred. Gary Thibodeau said that seemed extreme. Patricia said that deed fraud is a felony and that her client had filed a complaint with the district attorney's office, which is not extreme, it is accurate. Gary Thibodeau went quiet and then said he would pass that along. Patricia told me about this conversation the same day, and I listened and felt the particular strange sensation of your own life being discussed by people on your behalf, the way your medical situation is discussed by doctors while you sit there being the patient. I was the patient. I had not chosen to be, but I was learning that sometimes the situation chooses you, and all you can do is make the best decisions available from where you are standing.
The district attorney's office called me 3 weeks after I filed the complaint. An investigator named Dennis Harlow, who had the measured, professional manner of someone who has heard many versions of many stories and has learned to reserve judgment until the documents confirm things. He asked me to come in, and I did, bringing everything I had brought to Patricia Voss, plus the notes I had made about the phone call with Marcus. He looked through everything with the focused patience of someone for whom thoroughness is not a virtue, but a job requirement. He asked me several questions. Had I ever authorized anyone to sign documents on my behalf? No. Had I ever given Marcus power of attorney? No. Had I been aware of the deed amendment at any point before the title company called? No. Had I benefited financially from the property in any way since my mother's death? No. Only the shared ownership of the asset itself, which I had not been able to access as intended, because the ownership had been fraudulently altered. He took notes throughout. At the end, he said, "Miss Callum, I want to be straightforward with you. What you are describing, if supported by the document evidence, is a serious crime. Forgery of a recorded real estate document plus the financial benefit derived from that forgery constitutes felony deed fraud in this state." I said, "I understand that." He said, "Investigations of this nature take time." I said, "I understand that too." He said, "I appreciate your patience." I said, "I have been patient for 6 years without knowing I was being patient. A little more is manageable." While the investigation moved at the pace that investigations move, which is to say, slowly and without the kind of updates that would make waiting easier, life continued in the way that life continues regardless of what is happening in the parts of it that feel most urgent. I went to school, I taught my students, I graded their work and attended their performances and called their parents when I needed to, and felt in those hours in the classroom the particular relief of a space where what was happening in my life was completely irrelevant to what was needed from me. Children need you present. They know immediately when you are not. I was present. It was one of the things that kept me functional in those months, the daily requirement of being somewhere for someone else that had nothing to do with property records or attorneys or the slow, grinding machinery of legal process. Della checked in on me regularly. She would appear at my classroom door at the end of the day with coffee and a look that said, "How are you actually?" And I would tell her, "Actually," which is different from the version I told most people. Actually, I was managing. Actually, I was angrier than I had expected to be. Actually, the anger was useful because it was cleaner than grief, and grief was what was underneath it. The grief of understanding that the person I had promised my mother I would take care of had been, for 6 years, quietly taking from me in a way that my mother would have been devastated to know. Marcus retained an attorney eventually. Her name was Sandra Cho, and she contacted Patricia Voss about 6 weeks into the process with what Patricia described to me as an opening position that suggested her client did not yet fully understand the severity of his situation. The opening position was that Marcus was willing to restore the ownership split to 50-50 going forward and repay the equity loan from future proceeds if and when the house was sold. No acknowledgement of wrongdoing, no immediate repayment, no compensation for the 6 years of altered ownership. Patricia Voss told me about this position with the neutral tone of someone who has seen this opening move before and knows exactly what comes next. I said, "What do we say?" She said, "We say no. We say that the correct ownership must be restored immediately through a court-recorded amendment, that the repayment of $84,000 plus interest must be structured with a concrete timeline and secured against the property, and that the acknowledgement of what occurred is non-negotiable, because without it the criminal complaint remains active and unaddressed." I said, "And if he says no to all of that?" She said, "Then we proceed on both tracks simultaneously. The civil case moves forward, the criminal investigation continues, and Marcus spends the next 2 to 3 years of his life in legal proceedings that will cost him far more than compliance would have." I said, "He should have thought about that 6 years ago." She said, "Most people in his position think about it now. That is why we are having this conversation." There was a mediation session in month 3. I sat on one side of a long table with Patricia Voss, and Marcus sat on the other side with Sandra Cho, and between us was a mediator named Howard Greer, who had the exhausted patience of someone who has spent 20 years in rooms where people who used to love each other are trying to divide things. Marcus looked different than the last time I had seen him, which was the previous Thanksgiving when I had sat at the table in our parents' house and eaten the meal he had made and thought, "My brother is a good person who has had hard years." He looked smaller, not physically, but the particular quality of him that had always occupied a room fully, the ease, the warmth, the effortless way he made people comfortable, that quality was diminished. In its place was something careful and contracted, the look of a person who is aware that the words he uses are being measured.
I looked at him across that table, and I tried to find the version of him that I had grown up with, the brother who had taught me to ride a bike in the driveway of our parents' house, and had picked me up from a bad date in college without asking questions, and had sat beside me in the hospital when my mother was dying, and held my hand when I could not stop shaking. He was in there somewhere, but also was the person who had forged my name on a legal document 4 months after she died. Both things were true, and I was learning that holding 2 true things about a person simultaneously is one of the more demanding things a human being is asked to do.
The mediation did not resolve in a single session. Howard Greer had warned us at the start that it rarely did, and he was right. What the first session produced was not agreement, but a clearer picture of where the gaps were. Marcus, through Sandra Cho, was still resistant to the formal acknowledgement of wrongdoing. His position, as articulated by his attorney, was that he had made a serious error in judgment during a period of financial crisis and personal difficulty, and that characterizing it as deliberate fraud was an overstatement that would have disproportionate consequences for him. I listen to this characterization with the careful attention I give to things I want to be sure I am hearing correctly before I respond to them. Then I said, through Patricia Voss, that forging a signature on a recorded legal document and then using that document to extract $84,000 over 6 years while sending the defrauded party annual tax bills is not an error in judgment. It is a sustained and deliberate course of action that required planning, execution, and ongoing concealment. An error in judgment is a single decision made in a moment of pressure. What Marcus had done had taken months to arrange and 6 years to maintain. Howard Greer wrote something in his notes. Sandra Cho looked at her client. Marcus looked at the table. I looked at Marcus, and I thought about our mother asking me to take care of him. And I thought, she did not ask me to cover for him. She asked me to take care of him. Sometimes those are the same thing. Sometimes they are the exact opposite. The second mediation session was 3 weeks later. Sandra Cho came with a revised position. Marcus was willing to formally acknowledge that the deed amendment had been filed without my knowledge or consent. He was willing to restore the 50-50 ownership immediately. He was willing to repay the equity in installments over 5 years, secured against the property. What he was asking for in return was that I withdrew the criminal complaint. I sat with that for a moment. Patricia Voss had prepared me for this possibility, and we had discussed it at length beforehand. She had told me that withdrawing a criminal complaint is not always fully within a complainant's control, that once a complaint is filed, the decision to prosecute rests with the district attorney's office and not with me, but that my cooperation, or lack of it, with the investigation would carry weight in how aggressively the case was pursued. She had also told me that this was a legitimate negotiating position on Marcus's side, and that accepting it was not weakness, it was a choice, and that the choice was mine to make based on what I actually wanted out of this process. I asked her what she would do. She said, "That is not a question I can answer for you." I said, "I know." I said it anyway. She said, "What I can tell you is that both options, cooperating with the prosecution or stepping back from it, are defensible depending on what matters most to you." I said, "I need to think." She said, "You have until next week." I went home and I sat at my kitchen table and I thought about what my mother had asked me and what Marcus had done and what justice actually meant to me versus what it was supposed to mean. I called Aunt Rosemary, not to tell her everything, though I ended up telling her most of it, but because she was the last person alive who had known all 4 of us, my parents and Marcus and me, as a complete family unit, and I needed that perspective. She listened to the whole story without interrupting, which for Aunt Rosemary was unusual, because she is a woman who comments on things in real time as a form of engagement. When I finished, there was a silence, and then she said, "Your mother knew, you know." I said, "Knew what?"
She said that Marcus had a weakness in him. She said Elaine loved him completely, that she was not blind. She used to say to me, Rosemary, Marcus is going to need someone to hold him accountable one day, and I hope when that day comes, it happens before he does something that cannot be undone. I sat with that for a long time. I said, do you think this can be undone? Aunt Rosemary said, the legal part, maybe. The brother part, that is up to you and him. She said, your mother did not ask you to protect him from consequences. She asked you to take care of him. Sometimes taking care of someone means letting the consequence land. I said, I know. She said, what does your gut tell you? I said, my gut tells me that if I pull back from the criminal process to make his life easier, I am doing the thing I've always done, which is absorbing the cost of who he is so he doesn't have to. She said, well, there you go. I told Patricia Voss that I would not be withdrawing my cooperation from the criminal investigation. I would accept the civil settlement terms Marcus had offered, the ownership restoration, the repayment plan, the formal acknowledgement, because those things were practical and necessary, and getting them resolved through mediation was faster and less expensive than civil litigation. But the criminal complaint was a separate matter, and I was not going to use it as a bargaining chip in a negotiation about money. If the district attorney's office decided to prosecute, that was their decision to make based on the evidence, and I would cooperate fully with whatever they needed from me. Patricia Voss said, understood. She said, I want to make sure you know what that may mean for your brother. I said, I know what it may mean. She said, and you are comfortable with that? I said, comfortable is not the word I would use. I said, I think it is the right thing. I think there is a difference between what is comfortable and what is right, and I have spent too long in this situation choosing comfortable. She nodded. She said, then let us finalize the civil settlement and notify Sandra Cho of your position on the criminal matter. I said, yes. She said, this is going to be hard. I said, it has already been hard. The hard part started 6 years ago when my brother made a decision in a room by himself that affected both of our lives and did not tell me. Everything since then has just been me finding out.
The civil settlement was finalized in month 4. Marcus signed the deed restoration, which was recorded with the county recorder's office and formally returned my ownership to 50%. He signed the repayment agreement, $84,000 plus 6 years of interest at a rate Patricia Voss had negotiated to be paid in monthly installments over 60 months, secured against his 50% share of the property, meaning that if he defaulted, I had legal recourse against his ownership stake. He signed the formal acknowledgement, a document that stated clearly and without euphemism that the 2020 deed amendment had been filed without my knowledge or consent and did not reflect an agreement I had made. I signed my portions of the settlement. Patricia Voss filed everything. Karen Osei at the title company, who had started this entire chain of events with a phone call about a flagged refinancing application, sent me a brief email saying that the title records had been updated and she hoped things were resolving. I wrote back and thanked her. I meant it. She had called me first, as the title required, and in doing so had handed me a piece of information that my brother had spent 6 years hoping I would never have. Sometimes the system works. Not often enough, but sometimes. The criminal investigation moved on its own timeline, separate from the civil settlement, the way that criminal matters do. Dennis Harlow called me periodically with brief updates, none of which contained the word conclusion. The district attorney's office was reviewing the documents. They had requested additional records from the county recorder. They had been in contact with a forensic document examiner regarding the signature. I had provided everything they asked for promptly and completely because I had decided that my role in the criminal process was to be a reliable and cooperative witness and not to manage the outcome.
The outcome was not mine to manage. It belonged to the process, and I had to trust the process, even though trusting processes is something I find genuinely difficult, because processes are slow and impersonal and do not account for the fact that the person at the center of them is a human being who is simultaneously trying to live her life and teach her students and not become someone who is defined entirely by the worst thing that happened to her. I kept going to school, I kept grading papers, I kept appearing at my classroom door every morning and being present for the children who needed me to be present. Della continued to appear at my door at the end of the day with coffee and the look. I continued to tell her, actually, I was tired. Actually, I was still angry. Actually, I was also, somewhere under the anger, beginning to grieve the version of my brother I had believed in, which was its own kind of loss and did not have a clean name. Marcus called me once during this period. I did not answer. He left a voicemail. I listened to it once and then did not listen to it again, and eventually deleted it. What he said in it was this: "Nadia, I know you are not going to pick up. I know you are cooperating with the investigation, and I know what that probably means for me, and I am not calling to ask you to stop. I am calling because I need you to know that I am sorry. Not sorry I got caught, though I understand if you think that is what this is. I am sorry I did it. I am sorry I did not call you when I was in trouble, and I am sorry I told myself that I was protecting you from it, when really I was protecting myself from having to admit to you that I needed help. I am sorry about the money, and I am sorry about the house, and I am sorry about Mum. She would be so disappointed in me. I know that. I know." I deleted the voicemail, not because I did not believe him, because I did not yet know what to do with believing him, and I needed to not know in private for a while before I decided what it meant for anything. Forgiveness is not a thing I arrived at quickly. It is not a thing I have fully arrived at now, but I heard him. I heard him say our mother's name, and I heard the specific weight of it in his voice, and I put it somewhere in myself to deal with later when there was room for it.
The district attorney's office filed charges in month 7. I learned about it from Dennis Harlow, who called me on a Thursday morning before school to tell me that Marcus had been charged with felony deed fraud and forgery of a public document. He told me that Marcus had been given the opportunity to surrender voluntarily, which he had done, and that he had been arraigned and released on his own recognizance pending trial. He told me that my cooperation would likely be needed as a witness if the case went to trial, and that I should stay available and continue to communicate through Patricia Voss. I thanked him and hung up, and sat on the edge of my bed in the early morning quiet and thought, there it is. The thing I had set in motion was now moving under its own power. I had not caused Marcus to forge my signature. I had not caused him to extract $84,000 from our parents' house. I had not caused him to send me tax bills for 6 years while concealing what he had done. All I had done was not cover it up when I found out. And yet, sitting on the edge of my bed that morning, I felt the weight of it, the specific weight of a decision that has consequences for someone you grew up with, someone whose bike teaching and bad date rescuing and hand-holding in hospitals is also true as the forgery, as true as the $84,000. Both things, always both things. I told Della that morning. She came to my classroom before the first bell, and I told her, and she listened, and then she said, "How do you feel?" I said, "I feel like I did the right thing, and I feel terrible about it at the same time." She said, "Those two things can both be true." I said, "I know." She said, "Are you going to be okay today?" I said, "I am going to teach 18 9-year-olds about long division and the American Revolution, and yes, I am going to be okay because I do not have the option of not being okay until 3:15. She laughed. It was the first time I had laughed in a while. It felt like unclenching something that had been held tight for a long time.
The children arrived at 7:58, the way they always did, with their backpacks and their noise and their absolute faith that the adult at the front of the room had things handled. And I stood at the front of the room and I had things handled, at least the things that were mine to handle in that space. And for 6 hours I was just their teacher, and not a person whose brother had been charged with a felony, and not a person who was grieving the family she had thought she had, and not a person who was trying to figure out what justice felt like from the inside when the person it applied to was someone she loved. For 6 hours I was just their teacher. It was enough. The case did not go to trial. Marcus pleaded guilty in month 10. Sandra Cho called Patricia Voss to notify her, and Patricia Voss called me on a Friday afternoon with the particular careful tone of someone delivering information they know has multiple layers of meaning. She said, Marcus entered a guilty plea this morning to 1 count of felony deed fraud. She said sentencing is scheduled for 6 weeks from now, and the prosecution will be asking for a combination of probation, community service, restitution, and a fine. She said the restitution will be separate from the civil settlement we already finalized and will be ordered by the court. I said, what does this mean for him practically? She said, a felony conviction means he will have a criminal record. Probation typically means supervised release with conditions. He is unlikely to face prison time, given that he has no prior record and cooperated with the plea. But I want to be clear that sentencing is at the judge's discretion, and I cannot predict outcomes. I said, okay. She said, I want to ask you something. I said, okay. She said, victims have the right to submit a statement to the court for sentencing. You are not required to do so, but you have the right. Would you like to? I sat with that for a moment. I said, yes. I said, I would like to. She said, I will send you the guidelines. I hung up and I went to my kitchen table, the table where everything had started and where I was apparently destined to process everything that mattered, and I opened a blank document on my laptop and I began to think about what I wanted to say to a judge about my brother.
Writing the victim impact statement took me 3 weeks. Not because I did not know what to say, but because I kept having to decide what kind of statement it was going to be. There are statements that are about damage, about tallying what was taken and making sure the court understands the full weight of it. And there are statements that are about something harder to name, the complexity of being harmed by someone you love, the way that the harm and the love do not cancel each other out, but exist simultaneously and must both be acknowledged, to be honest. I wrote 4 drafts. The first was too angry. The second was too forgiving, the kind of statement that minimizes what happened in the process of humanizing the person who did it. The third was better, but still felt like I was performing something rather than saying something true. The fourth was what I actually meant. I said that Marcus had stolen something from me that was not only financial. He had stolen 6 years of my ability to make informed decisions about a property that was partly mine. He had used our parents' legacy, the house they had paid for over 23 years on 2 ordinary salaries, as collateral for his own benefit without my knowledge or consent. He had maintained this deception across dozens of phone calls and visits and birthday messages, and he had done it in the shadow of our mother's death, in the period when I had trusted him most completely and when trust had cost me the most. I said all of that. And then I said that Marcus was not a stranger to me, and that his capacity for harm did not erase his history of love, and that I did not stand before the court asking for the maximum consequence or the minimum one. I stood asking for accountability, which is the thing that my mother's request that I take care of him had never actually exempted him from. The sentencing hearing was on a Tuesday. I took the day off school. I sat in the courtroom in a grey blazer that I had bought specifically for occasions that required looking like a person who has her life together, and I watched my brother stand before a judge and hear his sentence read.
3 years of supervised probation, 200 hours of community service, a $10,000 fine payable to the state, court-ordered restitution in addition to the civil settlement, structured to run concurrently with the repayment plan already in place, and a felony conviction that would follow him. The judge said several things during the proceeding that I have thought about often since. She said that deed fraud is not a victimless crime. She said that it undermines the integrity of public records that the entire property system depends on. She said that the particular cruelty of committing fraud against a family member is that it exploits the trust that makes families function. She said that the defendant's lack of prior record and his guilty plea were mitigating factors, but that they did not change what he had done or to whom he had done it. She said that she had read the victim impact statement and found it to be one of the most honest accounts of the complexity of family harm she had encountered in many years on the bench. I did not look at Marcus while the judge spoke. I looked at my hands in my lap, and I breathed steadily, the way I breathe when I am in a situation that requires me to remain composed. When it was over, I walked out of the courthouse into the afternoon light, and I stood on the steps, and I felt the particular sensation of something being finished that you have been carrying for a long time. Not relief exactly, not satisfaction, something quieter than either of those. The feeling of having done what needed to be done and arrived at the other side of it still recognizably yourself. Della had wanted to come with me, and I had told her I needed to do this part alone, which she had respected because she knows me well enough to know when alone is what I mean and when it is a thing I am saying instead of something else. I called her from the courthouse steps. She picked up on the first ring. She said, "How are you?" I said, "It is done." She said, "How do you feel?" I said, "I feel like I need to go home and sit at my kitchen table and have a very large cup of tea and not think about anything for about an hour." She said, "That sounds right." She said, "I will bring dinner." I said, "You do not have to." She said, "I know I do not have to. See you at 7. She hung up. I stood on the courthouse steps a little longer, in the grey blazer, in the afternoon light, and I thought about my parents and the house they had built over 23 years, and the children they had raised in it, and the people those children had turned out to be, and I thought, I did my best with what I was given. I think that has to be enough. I went to the house after the sentencing, not that day, a few weeks later. Marcus was still living there, which he was legally entitled to as a 50% owner, and I had not been back since before any of this had started. I called him first, through attorneys initially, and then directly when Patricia Voss said the legal formalities no longer required intermediaries, and I said I wanted to come and see the house. He said, "Okay." He said, "I'll be here." He sounded like the voicemail, like someone who had arrived at the understanding that there was nothing left to perform. I drove up on a Saturday morning. The house looked the same from the outside. The yard was the same. The front door was the same dark green it had been when my parents painted it in 2003. I sat in the driveway for a moment before I went in, the way I had sat in the parking lot of the title company nearly a year before, processing before I moved. Then I went inside. Marcus was in the kitchen. He had made coffee, the same coffee my mother used to make, the particular brand she had bought every week for 30 years without variation. He looked up when I came in, and the thing on his face was not the ease or the warmth or the effortless charm. It was something more careful and more honest than any of those things. He said, "Hi." I said, "Hi." He said, "Do you want coffee?" I said, "Yes." He poured it, and we sat at the kitchen table that had been our parents' kitchen table for 30 years, and we did not immediately say anything, and the silence was not comfortable, but it was honest, and I decided that was a place to start.
We talked for 3 hours. I want to be clear that this was not a reconciliation in the sense of movies and stories about family tend to imply, the version where understanding is reached and warmth is restored and things return to what they were. Things do not return to what they were.
The version of our relationship where I trusted him completely and did not ask questions was not coming back, not because I had decided to withhold it as a punishment, but because trust is not a switch that is flipped back on once it has been broken by something this deliberate and this sustained. What the 3 hours were was honest. Marcus told me things he had not said in the voicemail. He told me that after our father died, he had developed a gambling problem that he had managed to mostly conceal from everyone, that he had accumulated significant debt by the time our mother was sick, that when she died and the house passed to both of us, he had seen in the equity a solution that felt in the moment like borrowing against a future he would repay, rather than taking from a present he was damaging. He said, "I know that is not a justification." I said, "It is an explanation." He said, "Is there a difference?" I said, "Yes. One tells me why, the other tells me it was okay." He said, "It was not okay." I said, "No, it was not." He said, "I've been in Gamblers Anonymous for 8 months." I said, "I did not know that." He said, "There is a lot you do not know about the last several years." I said, "That was your choice." He said, "I know." I said, "Some of it is too late to change." He said, "I know that too." I walked through the house before I left. Marcus stayed in the kitchen while I did, understanding without being told that this was something I needed to do alone. I went through each room the way you go through a place you have not been in a long time, noticing what is the same and what is different because of time and what is different because of decisions people made. My mother's bedroom was mostly unchanged. Her dresser was still there with the same arrangement of items on top of it that had been there since I was a child. The small framed photo of her and my father at their anniversary dinner in 1994, the two of them looking at each other and laughing at something the photographer had not captured. I stood in front of that photo for a long time. I thought about what Aunt Rosemary had said, that my mother had known Marcus had a weakness and hoped the accountability would come before it was too late. I thought about what too late means in the context of a family. Is it too late when a crime is committed, when charges are filed, when a sentence is handed down? Or is too late the moment when the people involved look at each other across a kitchen table and understand that the version of love that requires no effort or examination is no longer available, and that whatever comes next will have to be built from something harder and more deliberate than what they had before? I did not have the answer. I am not sure there is one. I picked up the photo and looked at it, and then set it down exactly where it had been.
The house is still there. Marcus still lives in it. The repayment plan is in place, and so far, he has made every payment on schedule, which Patricia Voss confirms with a brief monthly email that says simply "payment received," and which I read and file in a folder the way my mother would have filed it, because organisation is a form of self-respect, and I learnt that from her, and I am not going to unlearn it now. I visit twice a year still, at Thanksgiving and in the summer, which is the same frequency as before, except that the texture of the visits is different now. We do not pretend. We do not perform the version of our relationship that is easy. We sit at the kitchen table and we talk about real things: his recovery, my work, the house, what to do with our parents' belongings that are still in the closets, waiting for a decision we have not been ready to make. It is not comfortable. It is more real than comfortable was. I have decided that I prefer more real, even when it is harder, because comfortable, in my family's case, turned out to contain a 6-year forgery and $84,000 and a title company phone call, and if that is what comfortable costs, then I would rather pay the price of honest and know what I am actually dealing with. Della says I have become very philosophical about the whole thing. I told her that I had no choice because the alternative is becoming bitter, and bitter requires too much upkeep for a person with 32 papers to grade every week. People ask me sometimes, when I have told pieces of this story to people I trust enough to tell it to, whether I regret not pulling back from the criminal investigation when Marcus asked me to, whether I think the felony conviction was necessary, or whether the civil settlement would have been enough.
I have thought about this question seriously because I think it deserves serious thought and not a reflexive answer that sounds principled but has not been examined. Here is what I actually think. The civil settlement addressed the property and the money. It restored what was taken in a legal and documented way, but it would not have addressed the forgery itself, the fact that my signature had been placed on a public document without my knowledge, which is a crime against the integrity of public records and not only against me personally. And it would not have required Marcus to face, in a formal and consequential way, what he had done. The guilty plea and the sentence did that. They made it real in a way that a settlement, which can be reframed as a business resolution, cannot make it real. I think Marcus needed it to be real. I think my mother would have agreed with me. I think she would have been heartbroken about the whole thing, and I think she would have understood that heartbreak and accountability are not incompatible. You can be devastated by what someone you love has done and still believe they need to face it. That is not cruelty. That is taking care of someone the way they actually need to be taken care of, which is not always the way they are asking for. I have been thinking lately about what I would tell someone who is in the early part of the story I was in, someone who has just received a piece of information about a family member that changes the shape of everything they thought they knew. I would tell them several things. I would tell them to get an attorney before they get emotional in a conversation with the person who harmed them, because information gathered before legal advice is information that may need to be managed carefully afterward. I would tell them that the instinct to protect the person who harmed you is real and valid and does not need to be argued out of existence. It just needs to be placed in its correct position, which is alongside the decision about what to do and not in front of it. I would tell them that sitting slowly is not the same as processing wrong, that sitting in parking lots and at kitchen tables and on the edges of beds in the early morning is a legitimate way of arriving at clarity. I would tell them that the moment the situation becomes irreversible, when the letter is sent, when the complaint is filed, when the plea is entered, feels like falling, even when it's the right direction. And I would tell them that the other side of it is not what movies suggest. It is not the clean resolution and the restored relationship and the lesson learnt in the final scene. It is just life continuing, with the changed shape of a thing you are learning to live with, which is, in the end, what everything comes to. You learn to live with the changed shape. You keep going. You grade the papers. You have the coffee. You sit at the table. You continue. My name is Nadia Callum, and I was 32 years old when a woman from a title company called me on a Wednesday afternoon and changed the shape of my family permanently. I am 33 now, and I'm sitting at my kitchen table, the table where I graded the papers and took the call from Marcus and opened the laptop to find an attorney and wrote the victim impact statement and drank the key Della brought me after the sentencing, and I am thinking about what this year has cost and what it has given me, and whether those two things are in any reasonable proportion. The cost is clear. A version of trust I will not get back, a version of my brother that turned out to be incomplete, a year of legal process and emotional weight, and the particular exhaustion of having to be more deliberate and more awake than you wanted to have to be. What it has given me is harder to name. Clarity, I suppose. The understanding that love and accountability are not opposites, and the willingness to hold both at the same time is not a betrayal of one in favor of the other. The knowledge that I am capable of making hard decisions and living in them without being destroyed by them. The house is still there. It is 50% mine in the records that matter, the official ones, the ones that cannot be amended without my actual signature.
My parents built it over 23 years, and it is still standing, and it is ours, and the photo on my mother's dresser is still exactly where she left it. That is what I have. It is enough. If this story stayed with you, share it with someone who needs it. Drop your city in the comments. Hit subscribe. I'll see you in the next one.